Welcome, welcome, welcome. Once again, we are back at Know Your Rights University, continuing on the document. What is a legal duty and how does it pertain to individual rights? Understanding the difference between public and private. Outline of the law. In law, you have got to be able to see in your mind's eye what's going on. Like when somebody calls into my show, that's Yusuf L talking, and they give me a scenario, the first thing that I picture in my mind is on what side of the fence is he talking about? If I'm getting a question about child support or a divorce, I know I am on the private side because family law is private side. If I am getting a constitutional question, I know I am in the public side. If I'm getting a contract question, I know I'm in the private side. If I am getting a criminal law question, I know I am in the public side. You know, it's just as soon as they bring these topics to you, the first thing in your mind should be, is this public or private that we're talking about? Because that's how the law breaks down. And that's the first thing you have to do to understand what is going on and how to get yourself out of this situation. So I'm going to give you a breakdown of the law. Natural law breaks down the private law. Then you have substantive and procedural law. On the public side, we have public law, constitutional law, criminal law, administrative law, tax law, public international law. On the private side, we have private law, contract law, property law, tort law, status law, private international law. Natural law is derived from the belief that human morality comes from nature. Everything in nature has a purpose, including humans. In short, any law that is good is moral, and any moral law is good. Legal positivism is a legal theory that is the opposite of the natural law theory. Natural law has basically 7 principles that it rests upon, and they are mentalism, correspondence, vibration, polarity, rhythm, cause and effect, and gender. From natural law, we get something that is called positive law or man made law, and they are the trustees of law. They are supposed to be. Positive law is the working of the law through the authority of the state. Substantive law is the part of the law that creates, defines, and regulates rights, including, for example, the law of contracts, torts, wills, and real property, the essential substance of rights under law. Procedural law is law that prescribes the procedures and methods for enforcing rights and duties and for obtaining redress, as in a suit, and that is distinguished from law that creates, defines, or regulates rights, substantive law. Remedial law is that which affords a remedy, as a remedial statute, or one which is made to supply some defects or abridge some superfluities of the common law. The term remedial statute is also applied to those acts which give a new remedy. Public law is that body of law dealing with the relations between private individuals and the government, and with the structure and operation of the government itself. Constitutional law, criminal law, and administrative law taken together. Private law is that body of law dealing with private persons and their property and relationships. See special law under law. Public rights doctrine. The public right exception is carefully limited to the rights allocated by Congress that derive from government sovereignty or a public purpose, not from private rights designed to be adjudicated in common law in Article 3 courts. The classical public rights doctrine, growth of the administrative state. In the 1870 Illinois Constitution, on page 159, it reads, "The original jurisdiction of the Supreme Court in mandamus is not exclusive. as far as it extends. It is concurrent with that of the circuit courts. Since 1907, however, it has been held that this jurisdiction is not a general one, but that it is limited to cases where the rights, interests, or franchises of the state or of the whole people are involved, or where high official duties affecting the public at large are to be enforced, and to emergency cases relating to local public interests or private rights. Whether a given case is of such a character is to be determined by the Supreme Court in the exercise of its discretion. Illinois Constitution line of demarcation between public and private. Due process as a test of the substance of legislation. As has been stated earlier in this note, the construction of this section has been extended to embody a test of the reasonableness of legislative interference with individual rights. The General Assembly may enact regulations designed to secure and guard the health, morals, safety, and general welfare of society. These regulations, enacted in the exercise of police power, operate by the suppression of the liberties of the individual and the restriction of his use and enjoyment of property. This section, under its extended construction as a test of reasonableness and appropriateness to be applied by the court, is the dividing line between legislative power and private rights. It's interesting in this last sentence. It makes me think of a case I remember reading. I believe it was, what was that? I think it was called, what is that case called? Arizona versus, I forget the name of the case, but Arizona versus Miranda, I believe it's called. But it was said in that case where rights protected by the Constitution are concerned, there can be no rulemaking or legislation which would abrogate them. So, in other words, the legislature cannot make any rule or law that would take away your fundamental rights protected by the Constitution. Well, let us go on. Nature of police regulations. It is recognized that the state under the police power may exercise a wide degree of control over businesses affected with a public interest, such as common carriers and railroad, banking, warehousemen, and grain elevators, public utility companies, insurance, and places of amusement, but not a public golf course. Illinois Supreme Court case, taxing power of the state of Illinois. The Supreme Court of the United States has long recognized that, in general, Congress may not withdraw from judicial cognizance any matter which, from its nature, is the subject of a suit at the common law, equity, or admiralty. Murray's Lessee versus Hoboken Lands and Improvement Company. The court has also recognized that at the same time, there are matters involving public rights, which are susceptible of judicial determination, but which Congress may or may not bring within the cognizance of the courts of the United States as it may deem proper. Several previous decisions have contrasted cases within the reach of the public rights exception, those arising between the government and persons subject to its authority in connection with the performance of the constitutional functions of the executive or legislative departments, and those that are instead matters of private right, that is, of the liability of one individual to another under the law as defined. Crowell versus Benson. This case involves the most prototypical exercise of judicial power, the entry of a final binding judgment by a court with broad substantive jurisdiction on a common law cause of action, when the action neither derives from nor depends upon any agency regulatory regime. If such exercise of judicial power may nonetheless be taken from the Article 3 judiciary simply by deeming it part of some amorphous public right, then Article 3 will be transformed from the the guardian of individual right and separation of powers, the court has long recognized into mere wishful thinking. Howard K. Stern versus Elaine T. Marshall. The several judges of the circuit courts of this state, before entering upon the duties of their office, shall take and subscribe the following oath or affirmation, which shall be filed in the office of the Secretary of State. I do solemnly swear or affirm, as the case may be, that I will support the Constitution of the United States and the Constitution of the State of Illinois, and that I will faithfully discharge the duties of judge of such and such court according to the best of my ability. American society, of course, bottoms its systematic definition of individual rights and duties, as well as its machinery for dispute settlement, not on custom or the will of strategically placed individuals, but on the common law model. It is to courts or other quasi judicial official bodies that we ultimately look for the implementation of a regularized, orderly process of dispute settlement. Within this framework, those who wrote our original Constitution in the Fifth Amendment, and later those who drafted the 14th Amendment, recognized the centrality of the concept of due process in the operation of this system. Without this guarantee that one may not be deprived of his rights, neither liberty nor property, without due process of law, the state's monopoly over techniques for binding conflict resolution could hardly be said to be acceptable under our scheme of things. Only by providing that the social enforcement mechanism must function strictly within these bounds can we hope to maintain an ordered society that is also just. It is upon this premise that this court has, through the years of adjudication, put flesh upon a due process principle. That's Bodie versus Connecticut. Monopoly definition: a privilege or peculiar advantage vested in one or more persons or companies, consisting in the exclusive right or power to carry on a particular business or trade, manufacture a particular article, or control the sale of the whole supply of a particular commodity, a form of market structure in which one or only a few firms dominate the total sales of a product or service. Monopoly, as prohibited by Section 2 of the Sherman Antitrust Act, has two elements: possession of monopoly power in the relevant market and willful acquisition or maintenance of that power as distinguished from growth or development as a consequence of a superior product, business acumen, or historic accident. United States versus Grinnell Corporation. A monopoly, condemned by the Sherman Act, is the power to fix prices or exclude competition, coupled with policies designed to use or preserve that power. U.S. versus Otter Trail Power Company. It is monopolization in violation of the Sherman Act for persons to combine or conspire to acquire or maintain power to exclude competitors from any part of trade or commerce, provided they also have such power that they are able as a group to exclude actual or potential competition, and provided that they have intent and purpose to exercise that power. Davidson versus Kansas City Star Company. Monopoly power. The monopoly power which must exist in order to establish a violation of Sherman Antitrust Act may be defined as the power to fix prices, to exclude competitors, or to control the market in the relevant geographical area in question. HF&S Company versus American Standard Incorporated. Whatever tends to prevent competition between those engaged in an employment or business impressed with a public character is opposed to public policy and therefore unlawful, and whatever tends to create a monopoly is unlawful, as being contrary to public policy. All grants creating monopolies and acts tending to prevent proper competition are, by the common law, illegal and void. If grants and contracts, the tendency of which is to create monopolies, are void at common law, then, when a corporation is organized under a general statute, a provision in the declaration of its corporate purposes, the necessary effect of which is the creation of a monopoly, will also be void. The public policy of a state may be indicated by the provisions of its Constitution as related to past and present legislation. Section 22 of Article 4 of the Illinois Constitution of 1870 provides that the General Assembly shall pass no special or exclusive law for granting to any corporation, association, or individual any special or exclusive privilege, immunity, or franchise, whatever. And Section 1 of Article 11 provides that no corporation shall be created by special law. The Constitution has thereby reversed the old policy of granting exclusive privileges to corporations of any kind. People ex rel. Peabody versus Chicago Gas Trust Company. From American Jurisprudence on Business Trusts, Section 2, Origin and Development of Business Trusts. The application of the trust principles to the conduct of commercial enterprise is said to have originated in Massachusetts as a result of inability to secure corporate charters for acquiring and developing real estate without a special act of the legislature. Also, it has been said that the type of organization commonly denominated Massachusetts Trusts originated because of the hostility of some states toward corporations and out of a desire to secure some of the advantages of incorporation without incurring the burdens and restrictions thereto. In any event, the Massachusetts Trust has reached its fullest development and use in that state. The jurisprudence on the subject has blown up in comparatively recent years, although the law reports contain several instances of the use of this form of commercial enterprise more than a century ago. As certain inherent advantages of the business trust over the other forms of commercial enterprise gained recognition, it was adopted to a wide range of business operations. Many large and well-known concerns have carried on their businesses under this form of organization, and it is interesting to note that the popular use of the term trust in connection with monopolies and combinations in restraint of trade is traceable to the employment of the business trust form of organization by some of the best known of such combinations. A public office is a public trust. Borough councilmen, as fiduciaries and trustees of the public interest, must serve that interest with the highest fidelity. The law tolerates no mingling of self-interest. It demands exclusive loyalty. The theory is that a public officer assumes the same fiduciary responsibility towards the citizens of his community as a trustee bears to a Sesque trust. They have the right to expect that in everything that appertains to their business or welfare, he will exercise his best judgment, unaffected and undiluted by anything which might inure to his own interests as an individual. People versus Charlo. These cases, I must add that these cases were particularly chosen for examples of the certain conflicts of interest that they present in further explaining and giving examples of what conflict of interests are and what types of conduct can invoke the conflict of interest statutes. We agree with the district court that given the holding of the Illinois Supreme Court, it must be taken as settled that a city official violates the Illinois conflict of interest statutes by agreeing to submit on behalf of the city a proposed consent decree to a federal court when the decree, if accepted, would give the official a personal interest. We believe that the conduct described by the Illinois Supreme Court and summarized by our colleague in the district court does not implicate the petition clause. And just as a notice to the listeners, the listening audience, this is not to be taken as legal advice. This is to be taken for educational and information purposes only. Here, in its conflict of interest statutes, Illinois has addressed a problem of compelling importance to its capacity to govern justly preventing political corruption or the appearance of corruption. The statute at issue addresses the particular problem of public officials achieving private goals through their official actions. It sets forth a simple, direct solution. Public officials may not negotiate on behalf of the government when they would also be negotiating on behalf of themselves. At the outset, it is important to note that the statute does not really restrict the individual government official's right to petition the government with respect to his personal interests. It merely requires that he not do so while representing simultaneously the official interests of the government. In making this distinction, the Illinois legislature recognized that at all times public officials are both public persons and private citizens. We often refer to these separate personae as their official capacity and their individual capacity or private capacity. We refer to their corresponding interests in these capacities as official interests or public interests as compared with individual interests or private interests. No law prevented the petitioners from petitioning the government with respect to their own needs. They only were forbidden from doing so while representing official interests. As the district court noted, the difficulty with the petitioner's reliance on the petition clause is that the fiduciary duty which Illinois imposes on its public officials does not prevent them from litigating their own rights or interests in court. It only requires that public officials keep their own interests separate from those of their constituents. Though the petitioners were the named defendants in the voting rights lawsuit, that lawsuit was not about their personal interests. Rather, it was about their official interests. It was about whether the city's at-large voting system unconstitutionally diluted the voting strength of the minority citizens. The petitioners may have had the right to come to court and argue that they had a protectable interest in being retained in unelected positions at a fixed salary, although the petitioners all admitted that they were not legally entitled to retention. But the question remains whether they had a right to protect this interest in the way they did as part of the voting rights suit, which they were negotiating on behalf of the city as a whole. The evil exists because the official is able to influence the process of forming a contract. However, the interest of the governmental body intensifies to the extent that serious negotiations and discussions regarding these public officials' employment and salary ensue, and that public officials has an opportunity to influence the negotiations in any way. The statute is violated. The statute is unique because only public officials can violate its provisions. These officials are held in public trust and owe a fiduciary duty to the people they represent. The highest standard of conduct demanded of public officers, coupled with the broad sweeping language of the statute, permits no other interpretation as to its intent and meaning. From Meacham on Public Offices and Officers, Section 1. Public office and officer defined. A public office is the right, authority, and duty created and conferred by law, by which, for a given period, either fixed by law or enduring at the pleasure of the creating power, an individual is invested with some portion of the sovereign functions of the government to be exercised by him for the benefit of the public. The individual is so invested as a public officer. An office, says Blackstone, is a right to exercise a public or private employment and to take the fees and emoluments thereunto belonging. An office is a special trust or charge created by competent authority. If not merely honorary, certain duties will be connected with it, the performance of which will be the consideration for its being conferred upon a particular individual, who for a time will be the officer. Justice Cooley, in Throop versus Langman. In State versus Stanley, where Chief Justice Pearson says a public office is an agency for the state, and the person whose duty it is to perform this agency is a public officer. This we consider to be the true definition of a public officer in its original broad sense. The essence of it is the duty of performing an agency, that is, of doing some act or acts or series of acts for the state. Restatement of the law. Second, torts. Section 874. Violation of fiduciary duty. One standing in a fiduciary relation with another is subject to liability to the other for harm resulting from a breach of duty imposed by the relation. Comments and illustrations. Comment. A. A fiduciary relation exists between two persons when one of them is under a duty to act for or to give advice for the benefit of another upon matters within the scope of the relation. C. Restatement second. Trust. Section 2. B. A fiduciary who commits a breach of his duty as a fiduciary is guilty of tortious conduct to the person for whom he should act. The local rules of procedure, the type of relation between the parties, and the intricacy of the transaction involved determine whether the beneficiary is entitled to redress at law or in equity. The remedy of a beneficiary against a defaulting or negligent trustee is ordinarily in equity. The remedy of a principal against an agent is ordinarily at law. However, irrespective of this, the beneficiary is entitled to tort damages for harm caused by the breach of a duty arising from the relation in accordance with the rules stated in sections 901 verses 9 through 932. In addition to or in substitution for these damages, the beneficiary may be entitled to restitutionary recovery, since not only is he entitled to recover for any harm done to his legally protected interest by the wrongful conduct of the fiduciary, but ordinarily he is entitled to profits that result to the fiduciary from his breach of duty and to the beneficiary of a constructive trust in the profits. Further, when there is a contract between the parties or when there has been an assumption of duty by a trustee, guardian, or executor, the beneficiary may be entitled to what the fiduciary should have made in the prosecution of his duties. Special application of these rules to agents and trustees, respectively, is made in the restatement. Second agency, sections 401 through 407, and in the restatement second trust, sections 197 through 226a. See also Restatement of Restitution, sections 138 and 190. The same underlying principles apply to the liability of other fiduciaries, such as administrators and guardians. The liability is not dependent solely upon an agreement or contractual relation between the fiduciary and the beneficiary, but results from the relation. C. A person who knowingly assists a fiduciary in committing a breach of trust is himself guilty of tortious conduct and is subject to liability for the harm thereby caused. See Section 876. The measure of his liability, however, may be different from that of the fiduciary, since he is responsible only for harm caused or profits that he himself has made from the transaction, and he is not necessarily liable for the profits that the fiduciary has made, nor for those that he should have made. Specific allegations of the rule are made in the Restatement Second Agency, sections 312 and 313, and in the Restatement Second Trust, sections 280 through 326. The same principles are applicable when one has colluded with other types of fiduciaries. Reporter's notes. Some fiduciary relations, such as those of trustee and beneficiary, principal and agent, and director in corporation, are the subject of a considerable group of substantive rules of law, and a breach of fiduciary duty has usually been regarded as controlled by the substantive law rules governing the relationship, but the action may properly be regarded as in tort for damages, being an equitable tort even when the action is in the traditional scope of equitable jurisdiction. Appropriate sections of the Restatement of Agency and Trust, for example, are cited in the text. One breach of fiduciary duty that is more commonly regarded as giving rise to an action in tort is the disclosure of confidential information. See, for example, Horn versus Patton and other cases hereunder. Comment C. One who assists a fiduciary in committing a violation of his duty is also guilty of a tort. See Rowan versus Lamar's Mutual Insurance Company. Cross references, American Law Review, annotations. Bank's duty to bank's duty to customer or depositor not to disclose information as to his financial condition. Liability of public accountant. Liability of incompetence estate for torts committed by guardian, committee, or trustee in managing estate. Under Illinois law, upon which this theory is based, recovery for a breach of fiduciary duty requires proof of three elements. Number one, a fiduciary duty exists. Number two, that the fiduciary duty was breached. And number three, that such breach proximately caused the injury of which the plaintiff complains. Under four clauses of the original Constitution, the presidency is an office of trust. The 1787 text plainly envisioned high federal office as a public trust with powers to be exercised in the interest of those who created the office and who confer the trust, the American people. This court, Supreme Court of the U.S., has framed this vision in fiduciary language, reasoning last year that an agent owes a fiduciary obligation to the principal, so an agent of the government and thus to the public it serves. Percoco versus United States. Fiduciary officers are not open to any person, no matter how disloyal or destructive. Private fiduciary offices, including trustee, executor, and officer, may only be filled by persons who are fit to hold them. The law is replete with rules that disqualify unfit nominees from serving as private fiduciaries. By this analogy, Section 3 of the 14th Amendment is a fiduciary disqualification provision akin to rules that courts across the country commonly enforce. Our 1787 Constitution describes the presidency as an office of trust, so the 1787 text in Section 3 are best read together as creating a fiduciary office and then as barring unfit persons from holding it. The word trust, always capitalized, appears 4 times in the 1787 Constitution. Every time it is used to describe offices under the United States. These 4 references to offices of trust must include the office of president. Otherwise, these 4 significant clauses, the impeachment judgment, the foreign emoluments, the elector's appointment, and the religious test clauses, will all be subject incongruously to presidential exceptions. When the United States prosecuted former governor of Maryland, the Fourth Circuit held that the governor is a trustee for the citizens and the state of Maryland, and thus owes the normal fiduciary duties of a trustee. Example: honesty and loyalty. United States versus Mandel, Fourth Circuit. See also at 1362, describing governors' fiduciary duties of honest, faithful, and disinterested service. Mandel arguably turned on an express provision in Maryland's post-Civil War Constitution. See Maryland Constitution, Declaration of Rights, Article 6, 1867. All persons invested with the legislative and executive powers of government are the trustees of the public. But last year, this court suggested that the rule that public officers are fiduciaries may find its source also in the common law of agency. An agent owes a fiduciary obligation to the principal, and so an agent of the government has a fiduciary duty to the government and thus to the public it serves. Percoco versus United States. And indeed, the principle that federal officers are fiduciaries is traditional. A century ago, prefiguring Percoco, this court viewed public officials as agents. The larger interests of public justice will not tolerate under any circumstances that a public official shall retain any profit or advantage which he may realize through the acquirement of an interest in conflict with his fidelity as an agent. If he takes any gift, gratuity, or benefit in violation of his duty or acquires any interest adverse to his principal without full disclosure, It is a betrayal of his trust and a breach of confidence. United States versus Carter. This agency reasoning follows from the fiduciary character of the public office. The Carter defendant was an agent and thus a fiduciary because at the time of his misconduct, he was a captain in the Army of the United States. If these kinds of public servants, Army captains, state governors, CIA agents, are all fiduciaries, then the President of the United States is too. The office is unique and national, but this means only that the confidence placed by the people is weightier. The public trust administered is greater, and any breach of fiduciary duty may cause wider damage. But from the settled law that government agents are fiduciaries, it follows that the fiduciary powers ought not be entrusted to persons who are unfit to serve, and however new this principle might be as applied to the presidency, it is commonly applied to private offices. Fiduciary language has also been used to describe this court and its employees. See Trump versus Mazars. Stating the long-standing practice imposes on us a duty of care. Statement of the court concerning leak investigation. Terming leak one of the worst breaches of trust in court's history and an extraordinary betrayal of trust. Marshall's reports and recommendations. Quoting Law Clerk Code of Conduct. The law clerk, like the justices, holds a position of public trust. As trusts and estates litigators know, settlers and testators are sometimes induced, whether by fraud, duress, undue influence, misplaced allegiance, sentiment, or other causes, to select as fiduciary persons who are, or who turn out to be, unfit to serve. The law, however, makes provision for such cases. So, for example, the ordinary fiduciary offices of trustee or executor may not be held by just anyone. The Uniform Trust Code counsels that a court may remove a trustee on the court's own initiative if the trustee has committed a serious breach of trust, or if, because of unfitness, the court finds that removal best serves the interests of the beneficiaries. Uniform Trust Code, Section 706B. The Uniform Probate Code provides that after a nominated person representative qualifies by posting a bond and filing a statement of acceptance of the duties of office, cause for removal exists if removal would be in the best interest of the estate, or if the representative mismanaged the estate or failed to perform any duty pertaining to the office. Uniform Probate Code, Sections 3-601, 3-611B. These uniform principles find specific expression in mostly state statutes and cases. We are going to stop right here. We hope that this information has been informative and educational to you, and we hope that you will submit a comment for any errors that we may have made, or any suggestion that you may have to improve upon these educational information subjects. We hope to see you next time. We thank you once again for tuning in to Know Your Rights University. Peace.